All right, I would like to welcome everybody to today's C2C, which is Chamber 2 Community Back to Business NWA series. And today we're going to be talking with Deb Finney. Deb is the Outreach and Education Manager for the Equal Opportunity, or Equal EEOC. I draw a blank on what EEOC stands for, I'm sorry. Equal Employment Opportunity Commission. I flip-flop the words there. Yes, for Equal Employment Opportunity Commission out of the Memphis branch. You are actually based out of Little Rock, so we do have an Arkansas person telling us the best tips and tricks here as we're dealing with EEOC concerns here in the COVID-19 world that we live in now. So I am going to kick it over to Deb and let her give her presentation here. If you have questions, please chat them directly to me, to Steve Cox, and I will be sure to pass those along during that time when we get the chance. But without further ado, I do want to thank our sponsor for all of our C2C this Back to Business NWA series that we have going on. So, and without further ado, I'll turn it over to Mrs. Finney. Deb.
Thank you, Steve, and welcome to everybody. We are definitely in, I guess, uncharted times right now, and employers have a lot of questions regarding what to do, how to do it lawfully, legally, comply with the law. How do you handle these things? We, EEOC, have faced some of those same challenges as an employer also, in addition to being the federal law enforcement agency that enforces the laws prohibiting discrimination. So what we're going to talk about today, and I'm going to share my screen here in a minute so you can have the presentation, and I'll kind of disappear. But we're going to talk about, the pandemic issues and the most frequently asked questions that we're getting from employers and some employees too. I have spent a considerable amount of time these past 9 weeks answering questions from employers, employees about issues that may arise or issues that have arisen in the workplace. And so we've compiled our most frequently asked questions, which we're updating because we're getting a significant amount of questions. And hopefully that will address a lot of the questions you may have. But if it doesn't, as Steve indicated, you can send your questions to him, or if you want to reach out to me at the end of the presentation, I'll have a slide with my contact information, and you can shoot me an email with your question, and I'll be happy to get an answer for you. Since this is new for us in a way, I may not have all the answers today, or may need to get do a little research and get back to you, or check with our office of legal counsel just to make sure that I'm giving you correct information. But I don't have a problem telling you if I don't know the answer, and I certainly don't have a problem getting assistance in finding you the answer. So we'll do that. So I'm going to go ahead and start sharing my screen, and we'll get into that, all right? Okay, so we know that COVID-19 has been declared a pandemic, a global epidemic, if you will. And we've had like 4 in the last century, the last one being the H1N1 that rose to the level of being a pandemic, and that was in 2009. And in 2009, EEOC issued guidance on those H1N1 pandemic issues. So that guidance was still relevant as it related to the ADA, if you will. That guidance was still relative, but we've updated a little bit with the coronavirus. So, all right, so we know that EEOC enforces the laws that prohibit employment discrimination based on race, sex, religion, national origin, age, color, disability, genetic information. So what we're specifically going to focus on today is the ADA and also the Rehab Act, which they mirror each other. The Rehab Act applies to federal employees, and the ADA applies to everyone else. which includes the requirement for reasonable accommodation and has specific rules about medical exams and inquiries. They continue to apply, but they don't interfere with an employer's right or prevent an employer from following the guidelines and suggestions made by the CDC or our state and local health authorities about steps that you should take regarding COVID-19. EEOC has compiled all of our resources related to the coronavirus in one easy place to find it, eeoc.gov/coronavirus. And you can go there and get our guidance, our resources, statement by the chair, any updates we have, all of that will be at that one location for you. So that's handy. So when we talk about the Americans with Disabilities Act and specifically the ADA, it's relevant to our pandemic preparation and how we handle pandemic issues throughout this pandemic in three major ways. So we know the ADA regulates an employer's ability to make disability-related inquiries and medical exams for applicants and employees, including those who do not have an ADA disability. We know it prohibits employers from excluding individuals with disabilities from the workplace for health or safety reasons unless they pose a direct threat. And we know it requires reasonable accommodation for individuals with disability absent undue hardship during a pandemic. So when we talk about direct threat is a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by a reasonable accommodation. When an employer makes those assessments about whether or not an employee may pose a direct threat in the workplace, the evidence which is used must be based on current, objective, factual information and not on subjective perceptions or irrational fears about a particular disability or about a situation. And our regulations identify the 4 factors you consider when you're determining whether a person poses a direct threat in the workplace. The duration of the risk. How long is that risk going to last? The nature and severity of the potential harm, the likelihood that harm will occur, and the imminence of the potential harm. So those are things we assess when we're doing a direct threat. So whether this pandemic influenza, COVID-19, rises to the level depends upon the severity of the illness, okay? If the CDC or the public health authorities determine that the illness is like seasonal influenza or the 2009 spring-summer H1N1, it's not going to pose a direct threat or justify disability-related inquiries. But based on the guidance of the CDC and public health authorities, as of March 2020, the COVID-19 pandemic meets the direct threat standard. So it is much more severe than the H1N1 influenza or SARS that we had in 2009, okay? And the Centers for Disease Control and Prevention, CDC, acknowledges the community spread of COVID-19. And resulting from that, we had closure orders, employers sent employees home to work at home, entertainment venues were closed, schools were closed, bars, restaurants, things like that. Those facts manifestly support that a significant risk of substantial harm exists by having someone with COVID-19 or symptoms of COVID-19 at the workplace, okay? So when we're looking at disability-related medical exams and inquiries, we know that the ADA prohibits you from making disability-related inquiries and requiring medical exams of employees except under limited circumstances. And it's regulated in the following way. Before you make a conditional offer of employment to an applicant, you cannot make any disability-related inquiry or conduct any medical exams, okay? Once you make a bona fide conditional offer of employment, but before that person begins working for you, you may make disability-related inquiries and require medical exams, okay? And then it changes once that person becomes hired by you and actually starts working. A disability related inquiry or medical exam has to be just, justified in business necessity. So that's the standard we've looked at. So let's look at some of the questions we're getting relating to that issue. How much information may an employer request from an employee who calls in sick in order to protect the rest of the workforce during the COVID-19 pandemic? So when you look at that, you may ask employees if they're experiencing symptoms of a pandemic, virus, fever, chills, shortness of breath, and we know those symptoms have expanded over the course of this pandemic. It started out pretty much like that, the fever, chills, shortness of breath, inability to breathe, and it's expanded into some people experience, digestive issues. Some people children have it manifested in different ways. So you can ask employees if they're experiencing any of those symptoms, okay? When may an ADA covered employer take the body temperature of employees during the COVID-19 pandemic? Taking temperature would be considered a medical examination generally, okay? But because the CDC has acknowledged community spread and issued precautionary measures to us, you may take an employee's temperature, okay? One of the issues surrounding it, a lot of employers are doing that, like when you're when you're showing up for work, they're taking your temperature. A couple things you need to be aware of. A person could be positive for COVID-19 and may not have fever. They may be asymptomatic. We have seen significant number of people that have tested positive that are asymptomatic. Person may also have a fever for another reason. I could have an abscessed tooth that's giving me a fever and it's nothing related to COVID-19, right? What you want to think about is your methodology for doing that. And are you doing it in a manner which protects an employee's information? So if someone has a temperature, are you taking that temperature where other people don't see them being turned away at the door? You just need to be aware that you don't want to make sure, you want to make sure that there's no confidential medical information or the hint that someone might be having some issues when you're doing that. Does the ADA allow employers to require employees to stay home if they have symptoms of COVID-19? Yes, the CDC says employees with symptoms of COVID-19 should leave the workplace. That's the guidance, right? So the ADA does not interfere with that. When employees return to work, does the ADA allow employers to require doctor's note certifying fitness for duty? Excuse me. Yes. These types of inquiries are permitted under the ADA because they would not be disability related, okay? Or if the pandemic were truly severe, they would be justified under the ADA standards for disability related inquiries. As a practical matter, however, I think we need to remember that doctors and other healthcare professionals may be too busy during and immediately after a pandemic outbreak to provide fitness for duty documentation. Therefore, you might have to be flexible and take a new approach in that, like reliance on a local clinic to provide a form, maybe reliance on an email or a phone call to certify that an individual does not have that pandemic virus. May an employer administer a COVID-19 test before permitting employees to enter the workplace? So the ADA requires that a mandatory medical test of an employee be job-related and consistent with business necessity. Applying that standard from the ADA to the current circumstances of the COVID-19 pandemic allows you as an employer to take steps to determine if the employee entering the workplace have COVID-19, because an individual with COVID-19 poses a direct threat to the health of others in the workplace. So you may do COVID-19 tested before they enter the workplace to determine if they have the virus. You need to follow the standard that you would test, all of your employees if you're going to do that. or all of the people in the same job category. And consistent with our ADA standard, you should ensure that the tests are accurate and reliable. There's a lot of bad tests out there, okay? And the U.S. Food and Drug Administration has guidance on their website that you can go look at about what may or may not be considered safe and accurate testing. So just make sure that, you know, if you're deciding to do that, that you're using what would be considered safe and accurate testing for the COVID-19. And note that accurate testing really only reveals if the virus is currently present. A negative test doesn't mean the employee hasn't had it or won't acquire it later. So, you know, you are allowed to do that if that's what you want to do. So just remember that the ADA requires you to maintain medical information confidential. So, and that applies to any information obtained during the COVID-19 pandemic. So if you require all employees to have a daily temperature check before entering the workplace, you know, can you maintain a log of results? Yes, if you want to, you may do that. You just need to make sure it's maintained confidentially. And so the ADA requires you to have all medical information about a particular employee stored separately from that employee's personnel file. Okay, you can't commingle the information in the personnel file. So you need to limit access to that confidential information. You can store all medical information related to COVID-19 in your existing medical files. So you don't have to create like a whole new separate file. And you know, you can put it all there. May an employer disclose the name of an employee to a public health agency when it learns the employee has COVID-19? And yes, you may. Public health agencies are tracking community spread, so it would be fine. May a temporary staffing agency or a contractor that places an employee in an employer's workplace notify the employer if it learns the employee has COVID-19? Yes, because the staffing agency or contractor needs to disclose the name of that person so the employer can determine if that employee had contact with anyone in the workplace. You wouldn't do that if someone had diabetes or had heart disease. You would not notify the employer of that. That would be, you know, contrary to what the ADA says. But because the CDC says no one with COVID-19 should be in the workplace, then you would need to let the employer know so that they can determine if this employee had contact with anyone in the workplace. Now, a question that comes up is, what if I have an employee who tests positive for COVID-19? We send them home. You know, do I tell everyone who the employee is that they may have come in contact with? No. What you are required to do, and it's not that they might not figure out who it is depending upon your facility, right? If you have 23 employees and all of a sudden one's not there, and the people that work with that person are told someone that you work with or someone that you have come in contact with at work has tested positive, they're likely to determine who that is, but you still can't release the name. And you do want to let people that have come in contact with that person know that they have potentially come in contact with someone so that they too can be tested and follow the procedures that you would do if someone may potentially be exposed. Okay. If an employee, let's look at hiring and onboarding. So because a lot of businesses are reopening, a lot of businesses are starting to bring back employees. So let's say you're hiring, and may you screen applicants for symptoms of COVID-19? And the answer to that is yes, you may, because an employer may screen job applicants after they make that conditional job offer and before they're put on the payroll. You have that window, right? As long as it does so for all entering employees in the same type of job. So that rule applies whether or not the applicant has a disability and whether or not, you know, we're in a COVID-19 pandemic. You can ask those disability related inquiries after a job offer and before they are put on the payroll. May an employer take an applicant's temperature as part of a post-offer, so you've made them a job offer, pre-employment, haven't put them on the payroll, medical exam. Yes, medical exams are permitted after you've made that conditional offer, but again, we remind you to keep it, be aware that some people with COVID-19 do not have a fever. So, may an employer delay the start date of an applicant who has COVID-19 or symptoms associated with it? Yes, because the current CDC guidance says that a person who has COVID-19 or the associated symptoms should not be in the workplace. So yes, you may delay the start date of someone who has COVID-19 or symptoms associated with it. May an employer withdraw a job offer when it needs the applicant to start immediately, but the individual has COVID-19 or symptoms of it? Based on, again, the current CDC guidance, that individual cannot safely enter your workplace, and therefore you may withdraw the job offer if it's a position you need to fill immediately, okay? May an employer postpone the start date or withdraw a job offer because the individual is 65 years old or pregnant, both of which place them at a higher risk from COVID-19. So just the mere fact that the CDC has identified individuals who are 65 or older or pregnant as being at a greater risk doesn't justify unilaterally postponing their start date or withdrawing a job offer. You can choose to allow telework or some other accommodation, or discuss with those individuals if they'd like to postpone their start date. But you can't have and I've had several questions sort of surrounding this, this issue. You can't unilaterally say anybody 65 years or older, pregnant, we're going to postpone your start date or withdraw a job offer or send you home. I had employers contact me about sending those people that were identified as high risk home. You can't do that under the ADA. All right. Let's look at reasonable accommodation. So if a job may only be performed at the workplace, are there reasonable accommodations for individuals with disabilities absent undue hardship that could offer protection to an employee who, due to a pre-existing disability, is at a higher risk for COVID-19? So there may be reasonable accommodations that could offer protection to a person whose disability puts them at greater risk from COVID-19 and request those actions to eliminate possible exposure. Even with the constraints imposed right now by this pandemic, some accommodations may meet an employee's needs on a temporary basis without causing an undue hardship to the employer. So let's think about this. So maybe someone has a disability that puts them at a higher risk for COVID-19, okay? But the job has to be performed at the workplace. They can't perform it at home. It's not a position that they can do at home. You would need to still engage in that ADA reasonable accommodation and just not automatically reject an accommodation. You would need to look at it. There may be low-cost solutions available with materials already on hand or easily obtained. There may be changes to the work environment, designating one-way aisles, using plexiglass to ensure a minimum distance between customers or coworkers, tables, other barriers, whatever, to reduce the chances of exposure. And you would need to look at that. And I think one of the things that is really important right now is flexibility by employers and employees to determine if some accommodation is possible in the circumstances. And you may also look at temporary job restructuring of marginal functions, maybe even temporary transfers to a different position, or modifying a work schedule or shift assignment may also permit an individual who has a disability to perform safely the essential functions of their job while reducing their exposure to others in the workplace. So that's something you would need to look at. If an employee has a pre-existing mental illness or disorder that has been exacerbated by COVID-19, may he now be entitled to a reasonable accommodation? So I think it's certainly true that many people feel significant stress due to this pandemic. But employees with certain pre-existing mental health conditions let's say anxiety disorder, PTSD, they may have more difficulty handling the disruption to our daily lives that has accompanied this pandemic. So, as with any accommodation request, you can ask some questions to determine whether or not the condition they're talking about is a disability, meets the definition of a disability under the ADA, which substantially limits one or more of their major life activities, right? Um, you can ask with them and discuss with them how the requested accommodation would assist them, enable them to keep working, to keep doing their job, and explore alternative accommodations that may effectively meet their needs. And if you need medical documentation, you can certainly request it. I think, again, keeping in mind there may be some delay in getting medical documentation right now, just to the nature of what we're going through. In a workplace where all employees are required to telework during this time, should an employer postpone discussing a request from an employee with a disability for an accommodation that will not be needed until that employee returns to the workplace when mandatory telework ends? So our agency went on 100% telework 9 weeks ago. So all 2,500 of our employees across the country, regardless of their job, went to telework at home. We're still taking charges. We're still doing investigations. We're still, to the extent possible to do investigations. Some businesses are not open at the moment. We're still talking with people, counseling people, still doing litigation, all those things. We're just doing it differently than we did before. So let's say someone knows that when they return to the workplace, they're going to need an accommodation. And should you postpone discussing that request? We would say not necessarily. You're obviously going to give a higher priority to discussing requests for reasonable accommodations that are needed in the moment while someone's teleworking. But you may begin discussing the request. That gives you, the ability to acquire the information you need to make a decision regarding the reasonable accommodation. And if it's going to be granted, it gives you the time to also make the arrangements for the accommodation in advance. There's certainly no reason to postpone it. What if an employee was already receiving a reasonable accommodation prior to COVID-19 and now requests an additional or altered accommodation? Doesn't change the ADA process. It would not be any different than if there had been no pandemic and you had an employee who has a reasonable accommodation and they now request an additional altered accommodation. You handle it the same way. You can ask the same questions. You can do the same process that you would. You may need to discuss with the employee whether it's the same or different disability, and why additional altered accommodation is needed. And that happens. Sometimes an employee with a disability has an accommodation that's working, but something arises and they need an additional accommodation. And you go through that process with them. Okay. During the pandemic, if an employee requests an accommodation for a medical condition, either at home or in the workplace, may an employer still request information to determine if the condition is a disability? Yes, if it's not obvious or already known. If it's an obvious disability, employee uses a wheelchair, employee has a sight impairment, employee has a, mobility issue. If it's an obvious impairment, then you don't have to request medical documentation. If you already know of the disability for whatever reason, then you may, you don't need to request additional information, but you may ask questions if it's not obvious or already known, or request medical documentation to determine whether they have a disability as defined by the ADA. So you didn't know that they had a disability that needed an accommodation, and it's not obvious, and you don't know about it, you can request medical documentation to make sure that person meets the definition of a disabled individual under the ADA, which again is the physical or mental impairment that substantially limits a major life activity that we talked about, or a history of substantially limiting an impairment. So you can ask for that. Okay. During the pandemic, may an employer still engage in the interactive process and request information from an employee about why an accommodation is needed? Yes, you may do this. You can ask questions to determine whether their disability necessitates an accommodation. Possible questions may include, how does this disability create a limitation for you? How is the requested accommodation going to effectively address the limitation? Is there another form of accommodation that could effectively address the issue? How would a proposed accommodation will enable that person to continue performing the essential functions of the position? Of course, that's when we say essential functions, the fundamental job duty, the reason that job exists, okay? You can ask those questions. If there's some urgency to providing accommodation or the employer has limited time available to discuss the request during the pandemic, may they provide a temporary accommodation? Yes, there's nothing that prohibits an employer from providing a temporary accommodation as an emergency measure right now. So given the pandemic, some employers have chosen to forego or shorten that interactive process, the exchange of information from the employee and the employer about the accommodation request, and they'll grant the request. And as things change, as restrictions change, they're partially, fully lifted, the need for accommodations may also change during that process. And that may result in more requests for short-term accommodations. You may wish to adapt your interactive process and devise maybe end dates for the accommodation based on public health directives. So you could put okay, we're going to do this accommodation through May 30th and, reevaluate. We'll check and see what the guidance is then, or if everything has been lifted or whatever. So you could set a temporary end date for an accommodation to revisit that. May an employer ask employees now if they will need reasonable accommodations in the future when they're permitted to return to the workplace? Yes, you can. You can tell them, hey, if you know you're going to need an accommodation when we start back to work, when the workplace reopens, let us know. And you can begin the interactive process, the discussion between yourself and the employee, focused on whether, they have a disability and the reasons accommodation is needed. It gives you a little lead time to work on that, getting people back in the workplace. Are the circumstances of the pandemic relevant to whether a requested accommodation can be denied because it poses an undue hardship? So yes, an employer does not have to provide a particular reasonable accommodation if it poses an undue hardship. And that means it's either significant difficulty or significant expense. In some instances, an accommodation that would not have posed an undue hardship prior to the pandemic may pose one now. So let's unpack that a little bit. So when we talk about significant difficulty and we talk about significant expense, generally what we're looking at, you look at your current circumstances and you can consider this in reasonable accommodation. Does it create significant difficulty in acquiring or providing certain accommodations, considering the facts of a particular job? So let me give you an example. It may be more difficult, significantly more difficult. Not just that it's difficult, it has to be significantly more difficult, okay? During this time to conduct a needs assessment on an individual or to acquire certain items. Delivery may be impacted. There may be whatever might needed to have happened may not be available or can't be delivered, particularly for employees who might be teleworking. Or it may be significantly more difficult to provide employees with temporary assignments or to remove marginal functions or to hire temporary workers for specialized positions. So if a particular accommodation poses that undue hardship of it being significantly more difficult because of this pandemic or during this pandemic, to do that accommodations, you still need to determine if there's an alternative that could be provided before you say you're unable to provide that reasonable accommodation, okay? So let's look at significant expense. So prior to COVID-19 pandemic, most accommodations did not pose a significant expense for employers, particularly when you considered them against your overall resources and budget, okay? But the sudden loss of some or all of an employer's income stream for many employers because of this pandemic is a relevant consideration. So you're going to look at loss of income stream and discretionary funds available when you consider those expenses, and when, is there an expected date that current restrictions will be lifted, or will new restrictions be added? That doesn't mean you can reject any accommodation that costs money. You just have to weigh the cost of that accommodation against your current budget and your current resources, and taking into account constraints created by this pandemic. And again, even under the current circumstances, there may be no cost or very low cost accommodations available, depending on what the person needs. But something that previously would not have been an issue might be an issue, particularly if you're an employer who's lost your income stream during this time. All right, let's look at return to work. As government stay-at-home orders and other restrictions are modified or lifted in your area, how will employers know what steps they can take consistent with ADA to screen employees for COVID-19? So when you're looking at that, what you want to assess and remember is that the ADA permits employers to make disability-related inquiries and conduct medical exams if job-related and consistent with business necessity. Inquiries and reliable medical exams meet that standard if it's necessary to exclude those employees because they would pose a direct threat. So we know the CDC says if you have COVID-19 or symptoms of, that you can't be in the workplace. So that would be acceptable to do that because they would pose a direct threat to the health or safety of the other workers in the workplace. It's determined based on the base objective medical evidence, direct threat, not, like we said, not the subjective or irrational fears. Our guidance right now is such evidence. So the guidance from the CDC is objective medical evidence. It's good evidence, right? So you're acting consistent with the ADA as long as your screening is implemented consistent with advice from CDC, okay? So that may include continuing to take temperatures and asking questions about symptoms, or requiring employees to self-report if they have any symptoms of COVID, of all those entering the workplace. So you can do that, okay? An employer requires returning workers to wear personal protective gear and engage in infection control practices. Some employees ask for accommodations due to a need for modified protective gear. Must an employer grant these requests? So you may require employees to wear protective gear, masks, gloves, whatever, and observe, of course, standard infection control practices, regular hand washing, social distancing, all of that. But let's say you have an employee with a disability and they need a related reasonable accommodation under the ADA. Maybe they have a latex allergy and can't wear latex gloves. You would need to provide non-latex gloves. That would be an accommodation, right? Maybe you have an employee who works for you who has a hearing impairment and lip reads. You may need to look at a different type of face covering that would allow them to see, to read lips, to do their job. Maybe you have people wearing protective gowns or protective suits, if you will. You may need to look at, if you have someone who uses a wheelchair, they may need a gown that's, designed for an individual who uses a wheelchair. So those things may come up and you would have to engage in that process, discuss the request, provide the modification, unless you can show it being an undue hardship of significant difficulty or significant expense, okay? What does an employee need to do in order to request reasonable accommodation from the employer because she has one of the medical conditions CDC says may put her at higher risk for severe illness from COVID-19? I think employers, they're seeing this already. I've had a number of questions, and I think you're going to see this if you haven't onboarded your employees who've been off work, if you've been closed. There are going to be people who are on that list that CDC says that puts them at a higher risk, and they are going to ask you for reasonable accommodations, okay? CDC has identified, I'll tell you what they've identified: individuals 65 or older, okay? People living in a nursing home or long-term care facility, which is probably not going to be an employee, all right? People of all ages with underlying medical conditions, particularly if not well controlled, including chronic lung disease, moderate to severe asthma, serious heart conditions, people who are immunocompromised, and they can be immunocompromised for cancer treatment, from smoking, bone marrow, or other organ transplants, immune deficiency, poorly controlled HIV or AIDS, prolonged use of corticosteroids compromises immunity systems, and other immune weakening medications. People with severe obesity, defined as a BMI of 40 and above, people with diabetes, people with chronic kidney disease on dialysis, and people with liver disease. So anybody who has any of those is at an increased risk for severe illness from COVID-19. And they may request from you a reasonable accommodation. So what does that person have to do? All they have to do is let you know they need a modification or an accommodation, okay? Now, generally speaking, most employees do not approach employers and say, pursuant to the ADA or the Americans with Disabilities Act of 1990, I'm hereby requesting a reasonable accommodation. They don't speak like that. They may come up and say, hey, you know, I'm at higher risk for exposure to COVID-19, and I need whatever that may be, okay? That is a request for an accommodation. That's the notice, the need and notice that you need to begin that interactive process, okay? So they must let the employer know that they need the change, or need some sort of an accommodation for a reason related to their medical condition. They can do it in conversation or in writing. It doesn't have to be in writing, but they can do either. You don't have to provide an accommodation that isn't requested. So you may have an idea that someone has a condition, but if they haven't requested a reasonable accommodation, you need to be careful of how you handle that. So CDC identifies a number of medical conditions that might place individuals at a higher risk, and I mentioned those to you, if they get COVID-19. An employer knows that an employee has one of these conditions and is concerned that his health will be jeopardized upon returning to the workplace, but the employee has not requested a reasonable accommodation. How does the ADA apply to that? So let's say, let me just use an example. Let's say, you have an employee who had an organ transplant. And so, that according to COVID-19, and I would think within a reasonable period of time, if they had an organ transplant 25 years ago, that's probably not going to put them at significant risk at this point. But let's say you have an employee that may have had an organ transplant, or you had an employee who has been undergoing cancer treatment. So they're immunocompromised, okay? So if that employee does not request a reasonable accommodation, the ADA does not mandate that you take any action. So if they haven't approached you, it doesn't mandate. But if you're concerned about that employee's health being jeopardized, ADA doesn't allow you to exclude the employee solely because that employee has a disability that CDC identifies as potentially placing them at a higher risk. So under the ADA, you would not be allowed to say solely because you're on this list that the CDC has that, we're making some decision adversely against you. You would have to show that the disability poses a direct threat to that individual's health that cannot be eliminated or reduced by reasonable accommodation. So under the ADA, direct threat is a high standard. It requires you, if you're using that direct threat as an affirmative defense to not applying not providing an accommodation, it requires you to show that the individual has a disability that poses a significant risk of substantial harm to his own health, okay? And that assessment can't be based solely on the condition being listed on the CDC list. You still need to make an individual assessment based on reasonable medical judgment about that employee's disability and how it's affecting them, and not the disability in general, using the most current medical information available and the based objective evidence. So you're still going to have to go through that interactive process and make that assessment, that direct threat assessment using those 4 factors we talked about: duration, length of risk, severity, probability, those things. So some of the things that may happen may be that, and you may have 2 employees in 2 different locations, and let's say they have the same situation that puts them on the list, and they both have said, they may need accommodation, or they may need accommodation, or you're concerned about bringing them back. It may be that with one employee, based upon how their disability is at that point, how their medical situation is, and the current objective medical evidence on them, would keep them from returning to the workplace, but it might not on another, based upon the objective individualized assessment of them. And other things that might factor into it is, the severity of the pandemic in a particular area. If it's an area where the pandemic virus is very low and the risk of exposure is very low, compared to maybe a hotspot, that would factor into it too. Okay. One of the things we like to remind employers about is we have seen an increase in issues relating to harassment by individuals of a particular national origin, race, or other protected characteristic. We've had Asian Americans, Asian Pacific Islanders harassed because of, this being dubbed the China flu and things like that. There's been harassment directed at these individuals. So we like to remind employers that this could come up, and you can help reduce that chance by explicitly communicating to the workforce that the fear of COVID-19 pandemic should not be misdirected against individuals because of, their national origin, race, or other prohibited bases. We do have practical tools available to employers to reduce and address workplace harassment. Our small business page on our website, the link is in the handout there, eeoc.gov/employers/small business. Has a number of resources. We also have an employer section on our website that has a number of resources. And we have a sample anti-harassment policy tips for small businesses, but it could apply, a small business, it could apply to any business, but they broke it down for small businesses specifically. We've been talking about this for 4 years now, the Select Task Force on the Study of Harassment in the Workplace, but they do have some valuable resources for an employer to utilize regarding harassment. We have the report, which you can read. We have checklists for employers who want to reduce and address harassment in the workplace. There's 4 separate checklists. And then we also have a chart of risk factors that can lead to harassment. And you can look through that, might look through that chart and say, hey, this kind of fits our workforce. We need to be extra vigilant. And it gives you ideas on, how to respond to those risk factors. So those are available on our website to help you if you need help. All right, so we ran through our most common questions. That's changing daily, receiving a lot of questions. But there's my contact information. If you have a question that you may not want to ask here, or something comes up, please reach out, email me. The 501-324 is my office number. I'm not in the office. The 901 is my cell, and you can call me on that cell phone as well, or email me, and I will get an answer for you. If I don't have the answer, or I'm unable to answer it at that point, I'm happy to do that. Did we get any questions? Do we have any questions?
We're not seeing any at the moment, but thank
Okay.
you very much for that wonderful presentation. If you stop sharing your screen here, we'll come back and get things wrapped up.
Okay, hang on.
But thank you so very, very much for helping out today and presenting that today, Deb. We are very grateful for the information. That was a lot of information, a lot of useful information and things that people might not necessarily think about moving forward and want to, be as a preventative measure for this. So thank you very much for your time. Sure. Thank you for those of us that were able to join today on today's C2C Back to Business NWA webinar that we are offering here. So again, you have Deb's contact information. We can also send out, we have a copy of the PowerPoint that we will also be putting up for our members to download as well. So thank you again to our sponsor for Cox Communications for sponsoring today's thing. And thank you, Deb, very much. And we appreciate it. Hopefully we'll be able to get you back when all this is back on the road. Maybe we can get you in person sometime.
Right. We'd be happy to.
All right.
All right. Thank you. Bye-bye.
All right. Well, thank you guys very much. Y'all have a good day.